My guest today is attorney Alexis Richards, and she is our probate and estate planning attorney here at the office. And Alexis, welcome back to the show.
Thank you for having me, Tom.
Alexis, there are really at least two types of probate that we use, and there might even be a third kind, but the two that we most often use are a summary administration and a full administration. So tell listeners, what is a summary administration?
A summary administration is a shorter version of probate where instead of going through a formal process of appointing an executor, spending 6 months to a year on an estate, the judge will issue a court order on certain assets and the value cannot exceed $75,000 and the estate cannot be indebted, but it's a way to transfer assets a little bit more quickly.
So if somebody came to you and said, Alexis, my mom has passed away, all she had was $50,000 in the bank, your first question to her would be, did your mom have any creditors?
That's my first question always.
Doctors, hospitals, credit cards, you name it. If mom had any creditors, then this summary administration is not available to the family.
Correct.
If the son says, no, mom did not have any creditors, she had $50,000 in a bank account. By the way, the bank account was in her name only. It was not payable on death to anybody. Then all of a sudden, then maybe a summary administration is available to the caller.
Exactly.
And so tell the caller a little bit about how a summary administration would work.
So the way a summary administration works is we try and get, all the information we can up front. We draft initial documents. We have the client sign them. And then if there's a will, we put the will on deposit with the court. If there's not, then we start the court procedure part on our end where we submit all the pleadings and submit the orders and everything we need to the judge, and then we wait for them to sign.
And so in the perfect world, the judge would sign an order of summary administration. You guys would then get a certified copy of it.
Yep.
You would give it to the client, and what would the client do with that order of summary administration?
Once we give the client the certified copy of the order, then we tell them to go to that particular financial institution, and then the financial institution will then distribute that asset according to what the order says.
So far we've just talked about just the son, but if mom had 3 or 4 kids, that order of summary administration would say, disperse the assets to all 3 or 4 kids.
Exactly.
And so that if the son were to take that order to the bank's going to then write, I don't know whether the bank would write one check to 4 of them or would write 4 separate checks to the 4
I'm
kids.
sure it would probably depend on the financial institution. Maybe they have each bank is different, has different ways of doing things, but we make sure we clearly spell it out who is supposed to be receiving what and their appropriate percentage.
So the summary administration, it works well for a bank account or maybe an investment account. It could certainly be used for a piece of investment property, but that piece of real estate would have to be worth less than
$75,000.
Okay. So maybe they just have a vacant lot somewhere down the road worth less than $75,000. We could do summary administration on real estate as long as it's worth less than $75,000.
Exactly.
What other assets have you used a summary administration for?
I've used summary administrations for homestead property. I have also used summary administrations for even sometimes checks. Sometimes people have a couple checks and the bank will then disperse according to what the order says.
That's right. Sometimes mom has passed away and lo and behold, checks come rolling in payable to mom, and there's no way to negotiate those checks without getting some kind of court order.
Right. And I have a lot of people that will say, oh, the bank told me I need letters testamentary or letters of administration. And sometimes, yeah, that is needed. But if we're able to do a summary, then we are able to put checks on there. Oh, and also sometimes life insurance policies, if they're small enough.
Exactly. Or even IRAs when there's no beneficiary.
I've done IRAs as well.
Yeah. So for the listeners out there, I want to distinguish that we said that the value of the estate has to be less than $75,000, not including the homestead.
Right, because that is exempt.
So we can still do summary administration on a homestead even if it's worth way more than $75,000. So if the caller called you and said, hey, Tom, Or Alexis, my mom has passed away. She owned a $500,000 home and $50,000 in the bank. We can still do summary administration.
We can still do it.
And really, the reason for that is that the summary administration, the courts and statutes really want to make sure creditors get paid, doctors, hospitals, credit cards, etc. We can do a summary administration on a homestead because here in the state of Florida, your home, the home you live in, both during your lifetime and upon your death, is not subject to creditor claims.
Right. And the other thing, too, that's required for summary is we have to show the court that the funeral bill was paid in full. That is an absolute requirement.
Exactly, because the funeral expenses are a creditor.
They're priority, too.
Even if the kids paid them, the kids are a creditor.
Yep.
Or if the funeral home has not been paid. And so when we do the summary administration on a bank account, we get an order saying, okay, bank, give this money to the kids.
Mm-hmm.
When we do a summary administration on a homestead, what does that order look like?
That order shows who it almost shows the same thing where you need to have it going to the kids.
And then that order gets recorded in the public records.
Yep.
And that order acts just like a deed.
Exactly.
So that's the summary administration, and the beauty of it is that it's a relatively short process. I mean, start to finish, what's it typically take you these days?
I tell people within 6 to 8 weeks.
So it has something to do with what the probate judge's schedule happens to be.
Correct.
Yeah, and as all judges and all things legal, things slow down over Thanksgiving and,
they do.
And holidays. Judges are taking more time off, and that means less time available for us to get court orders signed.
Definitely.
So that's a summary administration, and let's see. I want to say the other time we talked about using a summary administration when the value of the probate estate is worth less than $75,000. Mm-hmm. That does not include the value of the home. The home could be any value.
Right.
But a summary administration can also be used when the decedent has been dead for more than 2 years.
Mm-hmm.
And why is that?
That is because after 2 years, all creditor claims are barred in the state of Florida. And so the Florida statute says, well, the time is run for creditors to file a claim. And then after that point, you can do a summary administration for more than $75,000.
So mom might have passed away owing doctors and hospitals $30,000.
Mm-hmm.
We can't do a summary administration or a full administration without making sure that $30,000 gets paid out of her estate.
Right.
But if mom has been dead for more than 2 years, Florida statutes say that creditors, doctors, hospitals, etc., they got up to 2 years from the time the person passes away to file a claim in their estate, or their claim will be forever barred.
Yep.
So after 2 years, we can do the summary administration because we no longer have to worry about creditors.
Right.
And in that situation, not only could the summary include the homestead, but it could include unlimited amounts in a bank account.
Exactly.
Now, I don't know how the listeners will feel about this, but you and I occasionally, we have a situation where somebody comes to us and say, Tom, my mom died, all she owned was $20,000 in the bank, and she's got $50,000 in medical bills. Well, if we probated it, that entire $20,000 would be used. So we tell that caller, look, let that $20,000 sit there in the bank, wait 2 years from the date of your mom's death, then we do a summary administration.
Exactly.
Then we don't have to give notice to the creditors, and then we don't have to pay the creditors.
Correct.
1 minute.
And that occasionally happens. Somebody will call me and remind me and say, hey, Tom, I called you 2 years ago. You said call back 2 years later, and that's what they're doing.
Yeah.
It works quite well.
It does.
Hey, folks, my name is Tom Olson. The name of the show is Olson on Law. You're listening to News Radio, WFLA.